Welcome to Aspen Leading Edge. I'm Patty Roberts from St. Mary's University School of Law, and today's guest is Alex Kreit. He's the director of the Center on Addiction Law and Policy and associate professor of law at Chase College of Law at Northern Kentucky University. Welcome, Professor Kreit.
Thanks for having me.
Well, I am really excited about having you because I just want to know, how do you study addiction law and policy, and how do you get into that in the first place? Tell me a little bit about the work that you're doing in the area of addiction law.
Yeah, so I've been interested in drug policy issues, honestly, even since before I went to law school. Back when I was in college, I was involved in helping to start a student organization called Students for Sensible Drug Policy and was on its board of directors for a while. And it's the organization still going strong as a sort of student drug policy reform organization. And sort of one of the reasons I went to law school was my interest in drug policy reform, in specific criminal law reform more broadly. When I did my student note, it made sense to do it on something in that space. And I did it on a marijuana law issue that was a little bit before the Supreme Court's decision in Rate. So it was a kind of timely topic to be looking at that. And then when I practiced for a couple years at Morrison Forrester, they had a medical marijuana pro bono matter there. It made sense for me to get staffed onto that. And so sort of been something that I've been interested in a long time in terms of the drug policy space in general. And of course, when I made the transition in the academy, it's been one of my, sort of central area of research, looking at issues related to controlled substances law, particularly addiction law related issues.
So when we talk about cannabis law, marijuana law in particular, I imagine, given your interest from even before law school, that it's been rather tremendous development in the area. And so if you can just walk us through kind of how the law has changed generally since you were first interested, and maybe where you see it going in the future.
Yeah, I mean, for marijuana law specifically, there's been a tremendous change, as you've noted, in the past 2 to 3 decades, and especially over the past decade. When I first got out of law school in 2004, there were a handful of states with medical marijuana laws. The federal government was still at a pretty combative posture towards those states. People were being criminally prosecuted federally, and that really continued through the sort of President Obama's first term. There was still a pretty good amount of criminal prosecutions of folks who were running medical marijuana dispensaries in states that had legalized medical marijuana. It was a bit though like a game of whack-a-mole because the federal government didn't have the resources to go after anything other than a small percentage of folks in that space. Obviously, then Colorado and Washington legalized for recreational use in 2012, and that led the Obama administration to issue a sort of guidance enforcement memo that since then the federal government has basically taken a hands-off approach, right? So now we're in this sort of strange space where, more and more states have legalized for recreational use. I don't think there's anyone who thinks that the genie's going to get put back in the bottle on that. And the federal government has sort of allowed that to happen. But at the same time, federal law is still what it was with respect to marijuana's legal classification today, as it was when California passed the first medical marijuana law back in 1996. Marijuana is still a Schedule I controlled substance currently, although that there's an administrative proceeding going on, which might move it to Schedule III. But even if that were to happen, that really wouldn't solve the sort of conflict between federal and state law, because if it's rescheduled, that wouldn't permit the sale for recreational purposes, even sale for medical purposes. People would have to register with the DEA to comply with the Controlled Substance Act. I think people are unlikely to do that. So it's been kind of an interesting space, and it remains so. I think it's maybe one of the best examples of the dysfunction of Congress that we're in this situation where now, 12 years and counting since the Obama administration issued that memo that the federal government has been allowing states to implement these legalization laws, and the conflict just has not been addressed by Congress, right? Like the letter of the law still says it's illegal federally nationwide, and it results in complications. I mean, people are not getting criminally prosecuted, but there's still a number of difficulties that folks who operate businesses in the legal marijuana space have because of the federal prohibition. So it's an interesting topic for sure.
Absolutely. So as I recall, there's banking problems, right? You please explain a little bit for our listeners about that. And I know about as much as that there are banking problems.
Yeah, yeah. So that's, been one of the issues, right? Which is it's one thing if you want to open up a marijuana business and rely on the federal government's non-enforcement policy and being willing to take that risk. If you're a bank, you're much less likely to say, well, the federal government says it's not going to be enforcing these laws, so we can kind of go and service marijuana businesses and rely on that and say that we're okay. If you're a bank, if you are servicing clients who are distributing Schedule 1 controlled substances, you're going to be running into problems with federal money laundering laws. And so Julie Hill has written about this. She's written, I think, one or two law review articles kind of taking a deep dive into this issue. I think my sense is that more and more marijuana entities have been able to get banking services, and that more and more banks have been willing to take on marijuana businesses as clients relative to what it was 5 or 10 years ago, but it still remains a problem for sure, because as long as you have the federal prohibition, you have banks in a position where they are violating federal money laundering laws, potentially by having these entities as clients. And even if they think it's exceedingly unlikely that they would actually be targeted for enforcement by the federal government, you could see why banks would say, we're just not going to take that risk just to have a few more clients who are operating in this space.
Is that Julie Hill, the dean at Wyoming?
Yes, exactly.
Yes, okay. She's also been a guest on the podcast. So how many states now, and if you don't know the exact number, just generally approve the recreational use of marijuana?
So we've got about half of all states now that have legalized marijuana for recreational purposes, right? So
That's a
and I
lot of conflict.
yeah. And I think that it's slowed down a little bit in terms of, I think, this rate at which more states are legalizing, in part because states that have ballot initiative processes, that's where it's sort of, I guess, easiest, maybe is not quite the right word, but that's where it's this maybe lowest hanging fruit for folks who are in the marijuana reform space, because if they can fund a ballot measure, it's a popular enough issue that maybe not every state, but in the great majority of states, even pretty conservative states, these ballot measures are going to pass as long as they're reasonably well written. And so that has been sort of the primary thing fueling these state reforms. Most of them have been passed through a ballot measure. Now, there have been some that have passed through state legislatures, but that's a much harder lift. And so I think that has sort of slowed a little bit the rate at which states are enacting legalization measures, but I think we're probably going to still continue to see more and more states adopt marijuana legalization in the coming years. I think there was a period of time at the beginning where there was a thought of, well, maybe after 5 or 10 years, if the experience in states that legalized the beginning, if there are problems in those states, or if the political climate changes in unexpected ways, maybe we'll see some of them get repealed, or we'll end up in a situation where a handful have legalized, but it won't ever really be more than that. And I think we're kind of at the place where for most states, it's not really a question of if, but more sort of when there'll be legalization in any particular state. And same thing, I think, with the federal government. I mean, again, I think if we had a Congress that wasn't broken, I mean, I think that the conflict would have been solved legislatively by now, because it is just such a strange thing that you've got half the country with state legalization laws that are implemented, no federal enforcement, and yet federal law hasn't really changed to formally recognize that fact.
You would think that they would act, which they really need to, but on so many issues as well. So has there been a dramatic reduction then in the amount of incarcerations that we're having as a result of marijuana possession?
There hasn't, I mean, I think there's marijuana possession was never a huge driver of incarceration rates on its own. Certainly there's some incarceration for simple possession of marijuana, and more incarceration for possession with intent to distribute or distribution, those kinds of offenses. And so I think legalization for sure has had some impact on that. I think more probably than the incarceration rate is just the criminalization rate, right? I mean, arrests, marijuana, even though simple possession of marijuana has never been a huge driver of incarceration, it has been a pretty significant chunk of drug arrests in particular and really all arrests in general. Usually about half of all drug possession arrests, like over time, have generally been marijuana possession arrests. You've got, just a significant chunk of people being arrested for possession of marijuana. And even if it doesn't result in incarceration, it can result in a criminal record and can result in loss of benefits. It can sort of have somebody might get sentenced to probation and end up spending time incarcerated if they violate their probation. And it also, I think, is changing to a degree sort of some of the, in states that have legalized, some of the policing tactics that have been part and parcel of the war on drugs, especially with respect to pretextual stops and searches and drug sniffing dogs, that sort of thing. Legalizing marijuana doesn't sort of remove that or take all of that away, but it does reduce a little bit, I think, the incentive for police to engage in those tactics and the ease with which, for example, a police officer could say, I smelled marijuana in a car that I pulled over and do a search on that basis. And there's plenty of cases where the officer testifies that they smelled marijuana and they did a search on that basis. And lo and behold, they find a gun in the car, but no marijuana, where it seems perhaps that was just being used as a pretext to get into the car. So I think it's having pretty significant impacts in a number of respects in the criminal justice system. Although I think for incarceration specifically, it's not has not been a game changer. It certainly has had impact, but not humongous impact.
Well, thank you for sharing with us where we are in the cannabis law space. But I'd love to turn our attention now to the book that you have with Aspen, Criminal Law in Focus. And I know that you just had the second edition come out in February of this year. And so, first, I'd love for you to talk a little bit about why you wrote a criminal law book in the first place. I mean, what prompted you to say, you know what, I want to do something better?
Yeah, I think the criminal law casebook space is one that ever since I sort of entered the legal academy, my sense is certainly I felt this, and most of my colleagues I talked to at conferences and the like always seem to have certain dissatisfactions with the casebooks that were out there. I think that is in part because the leading casebooks are from sort of a different generation from the generation before mass incarceration and, are a little disconnected from sort of modern legal practice. And so I ended up getting a conversation with somebody who works at Aspen who stopped by my office at some point, and we were just chatting about criminal law and criminal law casebooks. And that ended up sort of resulting in me signing on to do to do this casebook, putting together a proposal for it, and was really been excited to do it. I mean, it kind of aimed in the book to address sort of, I think, three things that I think areas where I think was a need and is a need for improvement with respect to sort of the predominant curricular structure for criminal law casebooks. One is that sort of mass incarceration component, that just the current paradigm in almost every casebook, really until past few years, was to have a course framed around the justificatory theories of punishment, retribution, utilitarianism, and sort of a framework that almost suggested all punishment is justified, and we have to think about sort of why the punishment is justified, or maybe if there's unjustified punishment, it's sort of at the margins. And then in terms of doctrine, the course has been traditionally centered around general principles of mens rea and actus reus and homicide offenses. And this, I think, has been a fairly long-standing critique, but I think past 5-10 years, it's been growing even stronger. There was about 5 years ago, Alice Ristroff had a really fantastic law review article called Curriculum of the Carceral State, in which she sort of talked about this. And in that framework of the course, it's very difficult to cover and convey the reality of mass incarceration and address sort of drivers of mass incarceration, because a lot of mass incarceration is at least arguably unjustified. And if you have a framework for the course that is focused on the justification of punishment and thinking about how can we explain when the punishment is justified, it's much harder to have explanation within that framework of the unjustified punishment that takes place in our system. I think the second bucket is, and I think these three things are interrelated, is not enough connection to legal practice, right? So with the course centered primarily on homicide offenses and then general principles of actus reus, mens rea, the bread and butter kind of crimes that people are going to be working on as lawyers if they go into criminal legal practice, their possessory offenses, drug offenses, theft offenses, property offenses are either relegated to an afterthought in most case books, or for drug offenses in particular, oftentimes not covered at all. Most criminal law case books do not have a chapter on drug offenses, and they may cover possession in the context of actus reus, but not really as a standalone offense to study and look at the doctrine of possession. And then I think the third bucket is, I think in a lot of criminal law courses and with a lot of criminal law case books, there can be a frustration of confusion among the students for a couple of reasons. I think one is the structure of focusing in on sort of these general principles, actus reus, mens rea. When people are prosecuted, they're prosecuted for specific offenses. And so most criminal law casebooks, and therefore most criminal law courses, spend a good amount of time at the beginning before even ever covering a specific crime, talking about mens rea, talking about actus reus, thinking about the differences between recklessness and negligence and recklessness and knowledge, and et cetera. But then students become kind of confused about, well, how does that really fit in to the actual crimes and what's going on in real world criminal prosecutions? Related to that, I think, is that criminal law has an exceptional amount of jurisdictional variation because we have the common law tradition or source of criminal law. We have the model penal code as a source of criminal law. And sometimes courses can be framed in looking at the common law approach to X and the model penal code approach to Y. But oftentimes there's many more approaches than just those. And it can become sometimes, I think, overwhelming for students when case books might be jumping between different jurisdictional definitions or approaches without giving them enough context of just the broader lay of the land, right? That this is a field of statutes, that state legislatures can and often do tinker with a definition of these crimes, in part because it can be a heavily politicized topic. It might only take one high-profile case to lead a state legislature to add some new variation to its definition of a particular crime. And that can, I think, cause confusion and angst for students because they're going through a course and sometimes wondering, well, which definitions do I need to know? Why did these three cases I read seem to be in conflict with one another? And so I think those are the three main things that I tried to tackle with the casebook, to have it be a more updated approach in terms of the pedagogy, in terms of giving more context for students so that there's less confusion and greater clarity about what they are learning and why, that there's a greater connection to legal practice with more coverage of theft offenses, a substantial chapter on drug offenses, and then trying to center the concept of issues related to mass incarceration throughout the course.
Well, I appreciate that you're exploring mass incarceration and whether it's justified, as opposed to having the books in the past that you're talking about that make the assumption that it was justified. And so that certainly is a threshold question and policy matter that our students should wrestle with. I noticed too that you have a couple topics in recent developments of the law. You have several new topics, but a couple that are of a lot of interest other than the legalization of marijuana includes the criminalization of homelessness and then causation and parental liability for a child's violent acts. So can you tell us a little bit about what prompted you to include those and what you found and included in the book?
Yeah. So, and I should say also in terms of sort of the justification component, I think just an interest of clarity, I think other case books aren't necessarily saying, well, all of this is justified, but they have a framework in which it's very difficult to incorporate the reality of mass incarceration and the unjustified punishment, because if your framework is focused on justifications of punishment and there's not sort of within that framework the concept of, well, what might drive unjustified punishment, it's really hard to cover that in anything other than kind of an afterthought in the course, right? And I think that's one of the things where I think other books have tried to incorporate here and there some mass incarceration components, but it's just very difficult in that predominant curricular structure. Second edition, I have included an edit of the Supreme Court's decision in the homelessness case. This is a case that got a fair amount of coverage. It addressed doctrinally kind of the question of, and this goes to sort of the idea, the actus reus material, right? But whether this was a statute in Oregon that was criminalizing conduct, and the Supreme Court in the past, in a case called Robinson, had drawn a distinction between criminalizing conduct and criminalizing status, and held that legislatures can't constitutionally criminalize mere status, they can only criminalize conduct. The Supreme Court held that Oregon statute was criminalizing conduct, the sleeping out of doors, and not criminalizing status. In the second edition of my casebook, I have an edit of that case. I include it, though, not in the sort of actus reus material to try to have the focus as much as possible be, because I think the actus reus part of it is interesting and there's coverage of that part within the casebook, but I think almost more interesting is using that as a tool of thinking about the reality of criminalization in the United States, right? What it means that we have so much criminalization of homelessness and why so many state and local officials seem to view the criminal law as a tool to be used to address homelessness, which I think the sleeping out of doors, if you were to think about it through just the lens of retribution, utilitarianism, it's, in my view, very difficult to justify the idea of criminal punishment for that act, right? And so, I have that case sort of in the, towards the end of the first chapter, use it in the book as a tool for kind of drawing out some of those themes. And again, themes that connect into the reality of mass incarceration. So, some of the other changes in the new edition include a much heavier emphasis on statutory interpretation, including a few U.S. Supreme Court cases from the past couple of years. I think particularly my sense is for the next gen bar, there's still not been a ton released about criminal law on the next gen bar, but from what has been released, my sense is that there's probably going to be even more of a movement towards the importance of statutes for criminal law in the next gen bar. And I think just broadly, there's been a lot of interest in focusing in on sort of statutory interpretation and the statutory component of criminal law just among a lot of criminal law teachers. And I think it's for a good reason, because I do think it kind of goes hand in hand with framework of thinking about criminal law through the lens of the justificatory theories of punishment, when the reality is it's, philosophers are not writing criminal law, state legislatures are, and it's statutory in nature. The justificatory theories of punishment don't constrain legislatures beyond just whatever the particular legislature is willing to pass. And criminal law, also because it's statutory, has so much variation from one state to another. So it's so important for students to be familiar with that. And so the first edition of my book, I had a reasonably good amount of coverage of statutory interpretation and sort of criminal law as a statutory body of law, but I've really kind of expanded on that even more in the second edition, including, as I said, some recent U.S. Supreme Court cases looking at statutory interpretation issues related to mens rea provisions in criminal statutes, related to the rule of lenity and those sorts of things.
Well, it sounds like a terrific upgrade to an already fascinating addition to the criminal law texts that are available. So again, this is Criminal Law in Focus, second edition, published in February 2025. Before we conclude, Alex, I wonder if you could share with me your thoughts regarding the question I ask all my guests, and that is, what are your predictions for the future of legal education in the coming decade?
It's a tough question given the current climate. I mean, I think just in general for the world of education, both higher education, but primary school education, particularly any school that's a public school. I teach at a state school. My kids attend public elementary school. I think, danger that we're seeing, or the trend that we're seeing, both at the federal level and then in some states, including where I teach, I live in Cincinnati, teach at Northern Kentucky, of politicians sort of seeking to interfere with academic freedom and interfere in really intrusive ways with sort of the educational agenda is incredibly frightening, right? And so I think my hope is that 10 years we will look back at this period as a very unfortunate blip, but just a blip in the trajectory of higher education, in education more broadly. But I think that it's going to take a lot of hard work to achieve that. And hopefully we don't end up in 10 years in a much darker world where we look back and see this period as the beginning of a trend to a much scarier place. As far as education, I had the chance a couple of times to teach in a study abroad program at a previous institution in China, teaching our students, but in China, classes in English. But just even still, there would be just the atmosphere of an educational institution in a place that doesn't have the same kind of freedom of thought that we have, even as someone who does not speak the language and who is teaching courses in English, it was noticeable. And there would be, at the beginning of the classes I taught, for the first couple classes, this student who was not enrolled, who I was eventually learned was basically sort of a minder or a student who was making sure that there was nothing, I guess, untoward being said or things that could be a problem that other Chinese students might be in the course listening to. I mean, I was teaching international and comparative white collar crime, so it wasn't really that kind of controversial subject, but for sure, just having even that sort of brief interaction with that kind of world makes me especially concerned about what I'm seeing. So I think that's hopefully will just be a blip, as I said. I think with respect to criminal law, I feel a little bit more optimistic in that I do think there's a little bit of a movement to address some of these issues. You had, as a guest recently, Andrew Crespo. He's got a great book with John Rappaport that's, I think, in a similar vein in terms of trying to address that disconnect between mass incarceration and the current criminal law curriculum. There's a really great book by Bennett Capers, Roger Fairfax, and Eric Miller that was published a couple of years ago. Alistair Stroff has a book with Callie. So I think that there is, I guess with criminal law specifically, maybe starting to be a little bit of a movement to update the curriculum of criminal law courses to better reflect the reality of criminal law today.
Well, congratulations again on Criminal Law in Focus, second edition with Aspen Publishing. I've enjoyed speaking with you. Again, today's guest is Alex Kreit. He is an associate professor of law and director of the Center on Addiction Law and Policy at Chase College of Law, Northern Kentucky University. If you've enjoyed this conversation and would like to listen to additional thought leaders in the Academy, I encourage you to check out other podcast episodes on your favorite podcast channel. Thank you.
Thanks.